So let me welcome everyone here to Cold War Studies Seminar. Today's Cold War Studies Seminar will be given by Nadia Boyajieva, who is a professor of international relations and international law at Plovdiv University and in the Bulgarian Academy of Sciences. She is also long been a visiting scholar here at Harvard's Davis Center. So I am very pleased that one of the subjects that she teaches is international human rights. And so I'm very pleased to welcome her here today to speak about that topic. So please, Nadia.
Thank you very much. Good afternoon, everyone. And thank you very much for invitation to give a talk at the Cold War Studies seminar series at the Davis Center for Russian and Eurasian Studies, where I have the privilege to be visiting a long-term visiting scholar and to enjoy the academic atmosphere at the Davis Center for so many years. So today I'll be talking about the international human rights framework and during the Cold War, and I'll be touching a few important issues. I'll be discussing not only the origins of the major international human rights regimes that emerged after the Second World War, but also how the Cold War affected, or more accurately, hindered the implementation of these regimes. By the term human rights, I'm referring simply to the basic political, social, and economic rights and freedoms to which all human beings are entitled. This includes, among others, the right to life, the right to liberty, the right to free expression, the right to own property, and the right to equal treatment before the law. The international human rights regimes that were organized after the Second World War were profoundly shaped by the war itself. That was a war that caused vastly greater destruction and misery than any other event in human history. The terrible bloodshed and upheavals of the war, culminating in Germany's mass extermination of Jews in Eastern Europe, were on the minds of Western politicians, policymakers, as they sought to forge post-war agreements that would guarantee basic rights and freedoms for all individuals. But the aftermath of the war had greatly complicated the prospects for the establishment of meaningful regimes on human rights. I would point out three circumstances that are worth noting. First, the Soviet Union under Joseph Stalin not only remained a tyrannical dictatorship itself, but also extended it in its influence through Central and Eastern Europe, setting this way a block of repressive communist regimes in the region. In the countries under Soviet domination, human rights were systematically violated. Second important circumstance, the turmoil and human dislocation in Western Europe and the general leftward shift in European politics that resulted from the war caused US policymakers to fear that the Soviet Union would use subversion and possibly even military action to extend communist influence into Western Europe. Later on, when Western Europe, with US assistance, of course, gradually recovered economically and came to enjoy a measure of prosperity, US leaders were no longer so fearful of Soviet communist expansion into Western Europe. But they continued to worry that the Soviet Union would try to expand into East Asia and other regions, other parts of the so-called Third World. Those fears were greatly heightened by the communist seizure of power in China in 1949 and the North Korean attack on South Korea in 1915. As a result, the US government was frequently willing to support authoritarian leaders in the Third World who would form a bulwark against the communist expansion. The third circumstance that I would point out and that complicated the establishment of meaningful human rights regimes after the Second World War was the continued existence of European colonial empires. Britain, France, and Portugal in particular maintained sizable overseas colonies, and initially they were reluctant to give them up. The difficult and other bloody process of decolonization in the 1950s, 1960s, and 1970s impeded the establishment of and implementation of the human rights norms. So this context, and together with the incipient Cold War, ensured that the negotiations and the enforcement of human rights accords after the Second World War would not be easy. Let me illustrate this by looking at the origins and fate of three major human rights documents. The 1948 Genocide Convention, the 1948 Universal Declaration of Human Rights, and the 1975 Helsinki Accords. All these three agreements were, in some sense, products of the Cold War, and the implementation of all three was hindered by the Cold War. Let me start with Genocide Convention. The term genocide was coined in mid-1940s, as we all know, by Raphael Lemkin, a lawyer of Polish Jewish origin who escaped from Poland after the Nazis occupied the western part of the country in September 1939. Lemkin fled to Lithuania and then to Sweden before eventually reaching the United States in April 1941. In November 1944, he published a lengthy book titled Axis Rule in Occupied Europe, which exhaustively documented the legal basis of the Nazis' policies of mass extermination, deportations, and slave labor. The book is best remembered nowadays for Lemkin's use of the new word genocide. He settled on that term after much deliberation and defined it as quote, a coordinated plan of different actions aiming at the destruction of essential foundations of the life of national groups with the aim of annihilating the groups themselves. Because the word genocide became associated with the Nazi Holocaust, it promptly gained wide currency as the standard by which to judge human rights destructiveness, a standard that might never be equaled. Lemkin himself, however, believed that the term should not refer only to carnage and atrocities of the magnitude perpetrated by the Nazis against Jews. He insisted it to encompass all attempts to destroy cultural, ethnic, or political identities, regardless of whether the perpetrators were seeking to exterminate every member of the targeted group. His vision, however, was only partly realized, as you can see when we look at the convention for genocide. Revelations at the end of the Second World War about the scale of Holocaust against the Jews spurred an effort within the newly created United Nations to set up an international legal convention agreement that would prohibit genocide and require signatory governments to take all necessary steps to prevent or halt it. Although political leaders were initially slow in moving on the issue, Lemkin did his best to keep the issue on the United Nations agenda. He repeatedly called on the world's governments to establish a legal framework that would apply to all acts of genocide, not just those committed during interstate wars. In December 1946, the United Nations General Assembly unanimously adopted a resolution denouncing genocide as, quote, the denial of the right of existence of entire human groups, end of quote, and describing it as, quote, contrary to moral law and to the spirit and aims of the United Nations, end of quote. The resolution also set up a committee to draft the an international treaty that would formally outlaw genocide. The result, after protracted and other negotiations, was the Convention on the Prevention and Punishment of the Crime of Genocide, which was approved by the United Nations General Assembly on a 55-0 vote in December 1948. The Genocide Convention was stated to enter into force after 20 of the 55 United Nations member states that voted in favor of it submitted their formal instruments of ratification. Although some signatories of the convention, notably the United States, took many years before they ratified it, ratification by the 20th country was completed in October 1950, allowing the convention to take effect in January 1951. The Genocide Convention defines genocide as, quote, acts committed with intent to destroy in whole or in part a national, ethnical, racial, or religious group. So I'm repeating, a national, ethnical, racial, or religious group. So this definition diverges from the definition of Lemkin's original draft, which included also political and social groups, as well as national, ethnic, racial, and religious groups as potential targets of genocide. The reason that the political and social categories were omitted from the final version of the treaty is that Soviet delegates insisted on removing them, a change that Lemkin himself deeply regretted, but did not publicly denounce. The extent of Soviet pressure on the matter is now even clearer from the evidence in the former Soviet archives, as well as Lemkin's own papers. The omission of political and social categories was crucial in that it essentially converted the Genocide Convention into a kind of Soviet instrument against Germany. The requirement that genocide is targeted against a specific cultural, ethnic, racial, or religious group omits some of the worst slaughters in the 20th century, including those perpetrated by the Khmer Rouge in Cambodia in 1975-1978, with a death toll as high as 2 million. By the same token, many of the atrocities committed in the Soviet Union under Stalin or in China under Mao Zedong would not be classed as genocide if the target had to be a specific ethnic or cultural group. Although Stalin did carry out mass deportations of nationalities in the 1930s and 1940s that resulted in huge loss of life, most of these other violent abuses affecting tens of millions of people were not directed against ethnic groups per se. The same is true of the most of the slaughters and systematic atrocities perpetrated in China under Mao. By excluding many of the worst abuses and crimes of the 20th century, the requirement of a targeted cultural or ethnic groups has arguably been the most controversial aspect of the Genocide Convention, an aspect that cannot be undertook outside the Cold War context. To help fill these crucial gaps, authors like Barbara Harf and Ted Robert Gar have argued that the concept of politicide should supplement genocide. Politicide, as Harf and Gar define it, refers to the killing of groups of people who are targeted not because of shared ethnic and ethnic or communal traits, but because of their, as they write, quote, their hierarchical position or political opposition to the regime and dominant groups, end of quote. This is largely in line with Lemkin's original intention. Similarly, other authors have suggested that the terms democide could cover all intentional killing of unarmed civilians by governments. The Soviet famine famine in 1930s, in 1932 and 1933, was also one of the examples when the question of when we can debate, was it genocide or politicide? But I would say here that the convention doesn't have retroactive action, so we cannot put those crimes under the genocide convention. Although the Soviet famine has come up particularly often in the discussions of genocide because of what some perceive as deliberate targeting of Ukrainians. But as I said, speaking legally, we cannot put it in the framework of the crimes covered by the Genocide Convention. The aspect of definition of genocide is largely in keeping with Lemkin's own preference for a broad scope and his belief that the motives of the perpetrators are irrelevant. This is his understanding. The convention, in specifying the type of acts it encompasses, suggests that genocide can occur even if no one can carry it out or intends to carry out mass killings. The Cold War, so the convention was drafted in 1948, came into force in 1951. But I would say that the Cold War that came in 1947, 1948, prevented any cooperation between the Western countries and the Soviet Union to bring charges under the Genocide Convention against the countries during the Cold War that would seem to have fallen within its scope, such as Burundi in early 1970s. Thus, even though the convention did lay the groundwork for charges against various perpetrators during the Cold War, it remained an ineffective document apart from its original application against Germany. In that sense, the convention during the Cold War lived up to what Stalin had sought. It became an instrument to wield against Germany, but one that would not threaten the Soviet Union or its allies. The next important document that was drafted in 1948 was the Universal Declaration of Human Rights. And this declaration was issued on the 10th of December, 1948, the day after the Genocide Convention was signed. The United Nations Human Rights Commission that shaped this document in 1947 and 1948 under the chairmanship of Eleanor Roosevelt was frequently buffered by the Cold War. Diplomats from many countries contributed to this final to the final text of the Universal Declaration. The original proposal for a statement concerning human rights was put forth by the Panamanian representative to the United Nations initial meeting in May 1945, Ricardo Alfaro, who believed that the statement should be incorporated in the United Nations Charter. Alfaro's proposal was based on his contacts with American and British legal specialists and intellectuals who have been calling in recent years for an international proclamation of basic human rights. The assembled leaders decided to form a human rights commission. It was created in 1946 that would be responsible for drafting an international treaty. But as it turned out, it was impossible at that time because of many obstacles to draft a treaty. That's why the members of the Commission drafted the Universal Declaration of Human Rights. 18 countries were represented in the Commission of Human Rights. I'll point out that the Commission of Human Rights was on one of the first bodies that was created under the United Nations to stress on the human rights, on the value of human rights after the Second World War. And that was, at that time, human rights were regarded to be focused not only of the countries, different countries, but to be the main focus of the United Nations Charter as well, and its bodies. No sooner had the Commission began its work, the disagreements emerged about the type of statement to draft and the specific rights to mention. These disagreements were exacerbated by the deepening Cold War and by the inception of decolonization, including mass bloodshed and that ensued with the partition of India and Pakistan. The legal scholar John Humphrey, with assistance from René Cassin and numerous others, hammered out the basic text, which was then scrutinized by the Commission against the backdrop of Cold War tensions over Czechoslovakia, Berlin, and the Soviet Yugoslav split. The impetus for including socio-economic rights in the declaration came not from the Soviet bloc, but from several Latin American countries. Later on, the Soviet Union and the communist governments were fond of claiming falsely that they were champions of socioeconomic rights over civil and political rights. But in fact, they were not the ones who promoted the concept in the declaration. Instead, the Soviet bloc countries wanted mainly to ensure that the declaration would have no binding effect on them and would not infringe their sovereignty. A portent of why the declaration subsequently proved to be of such limited effect. In the late September 1948, after the final text has been agreed in the Commission, the United Nations General Assembly directed one of its committees, the so-called Third Committee, to review the declaration carefully, article by article. Consideration to the document took far longer than initially anticipated, in part because of numerous amendments submitted by the Soviet Union and a few other countries. Each amendment had to be debated and voted on. One of the Soviet Union's proposed amendments is especially worth noting. That was a proposal to dilute the ban on torture by referring to the need to uphold local culture and customs. The Soviet proposal was supported by several Arab governments, but was vigorously opposed by the delegate from the Philippines, backed by the United States, who argued that any weakening of the ban would open the way for the types of practices endorsed by the Nazis. Ultimately, the amendment was rejected and the torture is expressly prohibited in Article 5. Another illustration, another interesting illustration of how Cold War politics entered into the deliberations was the Soviet Union's efforts to embarrass the United States on questions of racial equality. Article 2 of the Declaration affirms that, quote, everyone is entitled to all the rights and freedoms set forth of this declaration without distinction of any kind, such as race, end of quote. The Soviet delegation sought to include provisions for penalties against countries that engaged in racial discrimination. Although this amendment was rebuffed, the embarrassment it inflicted of the United States was one of the factors that caused the United States Department officials to realize that an end of racial segregation in the United States would be crucial for US foreign policy by eliminating an issue that would otherwise be exploited by the Soviet Union. Indeed, in subsequent years, State Department officials repeatedly testified before Congress that civil rights and an end of segregation would be highly beneficial for US foreign policy. When the full United Nations General Assembly convened on the 10th of December 1948 to consider the declaration, most of the disagreements that had been overcome, had been overcome by that time. Although the Soviet Union and its East European allies, as well as Saudi Arabia and South Africa, abstained on 7 of the 30 articles of the declaration, 48 countries voted in favor of the full declaration and none were opposed. The non-binding nature of the declaration ensured that it had no practical effect on the signatory countries, including the Soviet Union. By the time two follow-up covenants were negotiated, it happened in the 1960s, in 1967, in 1966. One was the International Covenant on Civil and Political Rights, and the other was International Covenant on Social, Cultural, and Economic Rights. The original goals of achieving binding commitments had fallen by the wayside. So those two covenants, they were elaborated in 1966, and they entered into force in 1976. 10 years were needed for governments to decide to put their signatures for these international treaties, because unlike Universal Declaration of Human Rights, these the treaties had binding effect. The changing complexion of the United Nations, which was increasingly dominated by the third world countries that wanted to resist any infringements on their sovereignty, that was a goal shared by the Soviet bloc, did not permit the establishment of binding agreements. So those two covenants, at that time, when they were adopted and opened for signature in December 1966, provided only for submission of periodic reports on human rights performance. Earlier proposals for intrusive UN investigations into suspected violations, the submission of complaints by individuals and NGOs were mandatory, and mandatory referral of violations on to the World Court were all dropped. Even though the optional protocol to the International Covenant on Civil and Political Rights that was drafted in 1976 to empower the protocol's Human Rights Committee to receive compliance and review cases, the committee in practice has done little, if anything, to redress or even try to deal with some of the worst human rights abuses. The third case I would like to discuss here is the Helsinki Accords and the role of the Cold War. The Helsinki Final Act was a direct product of the Cold War, but ironically, it proved to play at least a minor role in the end of the Cold War. The Helsinki Accord, which was negotiated among 35 countries from 1973 to 1975, was originally sought by the Soviet Union to provide international purification of the post-war boundaries in Europe. Western governments were willing to go along with it in return for Moscow's agreement to enter into talks on limiting conventional forces in Europe, talks that ultimately led nowhere. The West European governments also sought to balance the territorial provisions of the Helsinki Accords, which the Soviet Union favored, with specific provisions for human rights. The United States government joined the West European governments in seeking human rights provisions, but it was less enthusiastic about it. Under the administrations of Richard Nixon and Gerald Ford, Henry Kissinger played a dominant role in the United States foreign policy as both Secretary of State and National Security Advisor. He believed that the United States should not give any significant emphasis to human rights. This was especially true in the early to mid-1970s with the advent of a détente between the United States and the Soviet Union. At a time of warmer relations between the two superpowers, Kissinger did not want the relationship to be jeopardized by, as he called, extraneous considerations of human rights. United States diplomats during the Helsinki negotiations worked with their West European counterparts to arrange far-reaching provisions on human rights and human contacts. But they knew that Kissinger was relatively cynical about this part of Helsinki. Nonetheless, the Helsinki Final Act, signed by the 35 leaders on the 1st of August 1975, included numerous provisions regarding human rights in the first main part of the act. The part that was titled "Questions relating to security in Europe," specifically in Section 7 of Part 1A, titled "Respect for Human Rights and Fundamental Freedoms," including the freedom of thought, consciousness, religion, and belief. A later main part of the Act, titled "Cooperation on Humanitarian and Other Fields," included provisions for family contacts, family reunification, foreign travel, information, and other areas. The provisions on human rights did not go beyond what was already in the Universal Declaration in the two international covenants, but they did establish a human rights framework specifically for East-West relations. At the time of Helsinki Accords were signed, the human rights provisions gained relatively little attention and were overshadowed by the controversy surrounding the Western governments' seeming recognition of the territorial status quo in Europe. President Ford's decision to go to Helsinki to sign the accords came under strong protest, and many newspapers ran editorials criticizing the decision. The signing of the Helsinki Final Act even became a factor in the 1976 presidential campaign. Ford's main Republican rival, Ronald Reagan, denounced the Helsinki Agreement as a, quote, betrayal of American principles, end of quote. Ford defeated Reagan in the primaries, but the controversy weakened Ford's standing. The Soviet bloc governments in 1975 hailed the Helsinki Final Act for its confirmation of the territorial status quo in Europe. And they made no mention of the human rights and human contacts provisions. Nonetheless, some human rights activists and dissidents in the Soviet Union and in other communist countries, upon seeing the full published text, took the Final Act seriously, starting with the formation of the Moscow-Helsinki Group in 1976. This was an initiative of 11 leading dissidents, including Yuri Orlov, Lyudmila Alexeyeva, Yelena Bonner, Anatoly Marchenko, and Anatoly Sharansky, and others, 11 people. That was other small informal groups arose in Eastern Bloc to monitor compliance with the human rights provision in the Helsinki Final Act. The best known of these, in addition to the Helsinki Watch groups, was Charter 77 in Czechoslovakia, a small group of dissidents who signed their landmark statement in January 1977. Because the Helsinki Final Act included provisions for follow-up meetings, this gave the Western governments, including the Carter administration and the new human rights NGOs, an opportunity to press the East Bloc governments on their violations of human rights. These meetings became an important source of international pressure. And let me conclude. Nowadays, scholars and journalists and politicians often argue that the Helsinki Accords, through the rise of these informal human rights NGOs and the pressure brought to bear on the communist governments, accelerated the end of the Cold War, appealing as that argument might be, it is too simplistic and indeed erroneous. Neither the Helsinki Final Act nor the initial follow-up meetings in Belgrade and Madrid, nor the rise of Helsinki watch groups prevented the Soviet authorities from cracking down on the Soviet dissidents movement, essentially destroying it by 1982. Similar crackdowns occurred in the other Warsaw Pact countries, largely putting an end to the human rights movements in all communist states by the early 1980s. That trend might well have intensified had it not been for a change of leadership in Moscow in 1985 and Mikhail Gorbachev's subsequent decision in 1988 to move on a direction of political liberalization and a year later towards democratization. The fundamental change in the political climate in the USSR allowed human rights to emerge as a genuine factor in Soviet politics for the first time in history. Gorbachev's decisions to move in this direction did not occur because he admired Moscow, Helsinki Watch Group, or other dissidents. Declassified transcripts of Soviet Politburo document meetings from the mid to late 1980s underscore Gorbachev's contempt for Elena Bonner and his loathing of the entire dissident movement. Nonetheless, Gorbachev's disdain for the human rights activists did not prevent him from gradually coming to embrace much of their agenda, if only reluctantly, if he did it only reluctantly. By the end of 1980s, the Helsinki Final Act's human rights provisions were lending additional impetus to Gorbachev's political reforms. The Soviet leader would argue that the USSR would have to live up to its international obligations if it wanted to reap the benefits of greater interaction with the West. Hence, some specific legislation was introduced in the new Soviet legislature to comply with the Helsinki Accords. So in this sense, the Helsinki Final Act played a minor, though helpful, role in the Cold War's end. For more than 4 decades after the Second World War, the Cold War steamed efforts to ensure greater compliance with human rights and prevented the major human rights regimes from having any real bite. But the political dynamic in Moscow that led to the end of the Cold War elevated the importance of human rights in the Soviet Union and gave the issue a genuine place on the international agenda. Thank you very much for your attention.
Thank you, Nadia. So let me, before I open it for general questions and comments from the audience, let me ask a few questions here. I think I'll have a question about each of these, the three documents you've discussed here and the impact of the Cold War on them. First would be with regard to the Genocide Convention. It was already, and Lemkin was acutely conscious of this, it was already the term crimes against humanity. And that dates back to the 19th century. And so I'm wondering, Lemkin, by wanting a broad definition of genocide, seemed to be overlapping a great deal with crimes against humanity, whereas it would seem to me it would have made much more sense to limit genocide to, as you discussed, to efforts at mass extermination, the sort of thing that occurred during the Holocaust that arguably occurred in Rwanda in 1994, that you mentioned Burundi in the early 70s. But it doesn't occur very often. So I'm wondering, by pushing for a broader definition, did he leave it in a way that the Soviet Union could then, as you mentioned, and there's a very good book on this now by Anton, surname slipping my mind at the moment, but published a good book, as did Norman Neymark in his book on genocide, discussed the Soviet role in excluding political and social categories that, as you mentioned, left out the terrible slaughters under the Khmer Rouge in the mid-1970s. So I'm wondering, did Lemkin set up the convention, even though it didn't, because of excluding the political and social categories, it wasn't in strict conformity with what he had proposed, but by pushing for a broad definition, I'm wondering whether he just set it up to be thwarted in that way. So that would be, and then also you get the genocide, which becomes in later years used as a kind of political weapon, where you just express disapproval of almost any serious abuse by calling it genocide. So there are instances of genocide, but where it gets used for far abuses well short of mass extermination. So in any case, I do want to also ask with regard to the genocide convention. It was, though, applied, even though, as you mentioned, during the Cold War, it proved to be an empty document. It was used after the Cold War in the International Criminal Tribunal on the former Yugoslavia, and did actually result in convictions. I think around 120 officials from Serbia and from Croatia mainly, I think a few also from Bosnia, were convicted in part on charges of acts of genocide, which is a term used in the Genocide Convention. It's also, it was also used against several African countries, especially Sudan, leader who was convicted on charges of genocide. Unfortunately, Sudan is now back into a terrible war, but and elsewhere. So in the post-Cold War period, maybe because it no longer does have that detrimental impact of the Cold War, it has at least in part been applied. With regard to the Declaration on Human Rights, to what extent did this influence some of those in the Soviet bloc, in the Soviet Union, the dissident movement that took shape in the 1960s, who very consciously cited the human rights that are laid out in the Declaration on Human Rights? To what extent did it motivate them? I know that they often said that they were simply calling for the Soviet government to live up to its constitution, which did set forth some of these principles, even though they were never observed. But did the declaration itself have a direct impact on some of what the dissidents proposed, both in the Soviet Union and in Eastern Europe? And then with regard to the Helsinki Accords here, and you mentioned the review conferences. Were the review conferences in some ways more important than the Helsinki Accords themselves, in the sense that they gave a forum, and you mentioned this with regard to the Belgrade and Madrid review conferences, that they gave a forum to highlight the abuses that were occurring despite the signature of the Accords. And then particularly during the Gorbachev period, which, as you mentioned, allowed for human rights suddenly to become, in the Soviet bloc, important as well. Did those same, in the legislation you mentioned that was adopted, I think it was Alexander Yakovlev in particular who promoted that, in Shevardnadze, but did they, were they thinking about the review conferences and the potential for the Soviet Union to be embarrassed if it didn't pursue this type of legislation to comply with the Helsinki Accords? So anyway, those are a few questions for you.
I think,
Sorry.
I think we have to set up another seminar. I mean, so should I try to answer?
You can give brief answers and then I'll let you come back to whatever you want.
So the definition that Lemkin offered was quite a broad definition, and he was so his definition was kind of response and to the all acts against humanity and atrocities of the Nazis' crimes again after the Second World War. So he wanted to create a term that was related to this kind of crimes. Of course, there were crimes against humanity. That was term that was known already, but that is a very broad term. Crimes against humanity, and Lemkin wanted to focus on specifically on crimes that arose during the Second World War by Nazis. That's why he elaborated a new term to stress, to focus on those particular crimes. This is what I think. Crimes against humanity, this is a term that is, how to put it, it is used very often even until now. And here I'm making, I'm connecting with your other comment or question about international, about convention, the convention and its role. The crimes against humanity is very useful term for international courts and the International Criminal Court and national criminal courts when they don't want to call the crime that is actually that is crime that is genocide. They use this much wider term, much broader term, crimes against humanity. This is very useful, very practical, and I remember I've been to several conferences that when people and lawyers and policymakers were discussing why we still and international criminal court and or international court or ad hoc tribunals like the Tribunal for Yugoslavia or for Rwanda, although they finally reached the conviction for according to the convention. But why they prefer and prosecutors prefer to use crimes against humanity, because it's less politicized. It is less politicized, and also another thing is very interesting. There is no additional protocol to the convention against the genocide until now, because nobody wants to offer a protocol, and it is needed because the world changed so much, and we experience so much bloodshed, so many wars and different kinds of conflicts all the time, and we have crimes that can be qualified as genocide, but nobody wants to use this term genocide. It's like everybody is trying to put it in the more practical term, crimes against humanity, not to be blamed.
But it was used though in the International Criminal Tribunal on Yugoslavia, and there's quite a bit of
only Yugoslavia and Rwanda. Those two, they finally, had how to say finally those ad hoc international courts decided to put in the convention into force, into claim those crimes during the war in Yugoslavia and Rwanda as genocide. But nobody else And still experience we are witnessing so many crimes against that we can call genocide, but they're not called. And the main reason for this is it was after the Genocide Convention was signed in 1948. Until now, these are political considerations of different governments who don't want to go into debate because of with other actors on in international affairs. That was during the Cold War, but it continues at the moment. So we don't, and although a lot of politicians, a lot of journalists are pointing different crimes as genocide, they might be not genocide according to the terms of the convention. But this is a different matter. So now everybody speaks about genocide, but when it comes to legal actions, when it comes to decisions of international criminal court or ad hoc tribunals that have been created for prosecution of crimes during different nowadays conflicts, we see only two cases, Rwanda and the former Yugoslavia case, and that's it. And there have been a lot of discussion in literature, but also a lot of academic events. I've been witnessing and attending many of them, including events, very good international conference held in Berlin 2 years ago. When we were discussing, and I was discussing also my colleagues were discussing the case, the war in Ukraine now, and if and how Russia can be punished, violating international norms, and it is very difficult. Also, not to mention if in the conflict is involved international actor that is not only, of course, maybe it's not superpower, but if it's a member, if a permanent member of the Security Council of the United Nations, all these international norms, they cannot be put into action because immediately the country, the state will impose veto. So it is very complicated, but people until now are very, very using very often genocide. The word genocide, some people without even knowing what exactly genocide means and what exactly genocide, the provisions of the Genocide Convention. So they're referring to some other crimes that are not necessarily genocide. But those that are definitely genocide, nobody wants to put them in to call them genocide. So what else? That was the other, but primarily political considerations are the main that are that the political leaders are having in, and they prefer to have good relations instead of pointing other partner as genocide as perpetrator.
But the U.S. government, with regard to Russia's war crimes in Ukraine, did have, working with the EU, had underway an investigation of Russian war crimes. And one of the charges they were looking at was genocide, especially in Kherson, but also in Bucha. And one of those strongly supporting those investigations 2 years ago was Marco Rubio, who in his new role as Secretary of State under President Trump, put an end to the U.S. investigation. So the U.S. government now officially opposes any holding of account of the Russian government under President Trump. So that is, a deliberate step taken by one particular president, even though the Secretary of State that he has, who carried out that order, had 2 years ago spoken strongly in support of holding Russia accountable for genocide, or at least one of the charges. So in any case,
The problem is all that, law, legal provisions and legal treaties are one thing, but political considerations and political will is different, completely different. So we see many examples during the Cold War, and nowadays also we witness every single day different decisions or governments that are changing their opinion overnight when it comes to crimes that we can call genocide according to the provisions of the convention, but it's not politically correct, to put it this way. And
please go ahead, Elizabeth.
Yes,
Yeah.
It's okay. I don't need to.
No, please go
I
ahead.
think I had some.
Yeah, that's all right. We'll come back to those questions. Please go ahead.
I want to see if I can understand the core argument here. As I see it, you're suggesting that the Genocide Convention was not able to go into effect because of the Cold War, broadly speaking, right? I would love you to break that down, because part of the argument seems to be that it's the Soviet position on the Security Council that makes it very difficult. Some of it seems to be the Soviet control over Eastern Europe, which makes it very difficult, and they have a particular interest in not being investigated by everyone. So I'm not sure, is it that the Cold War means so many things, right? It means the decision to contain the USSR, as Keenan would have said, or it means the Cold War rather than the hot war. I think I understand that you're talking, in a way, you're saying it's because of the USSR's own resistance to being investigated.
No,
But maybe I didn't understand, so
No.
tell me, so explain it more fully. I'm sorry to be, if I'm the only one who
And-
didn't get it.
And just to follow up on that deal, in other words, why would the Soviet Union, as one of the permanent members of the UN Security Council, even agree to have a genocide convention, except I think, as you mentioned, that it was intended to be used against Germany specifically.
Right. So there's
how many millions from Soviet Union died?
Yeah, so they're willing to use it in the show trial, which they called it, of Nuremberg.
Yes,
Right.
of course.
And they wanted to be a demonstration trial. That was one of the
Yes.
interesting things about
Yes,
that.
yes. No, what I said that during the problem with all these international documents and treaties, because some of them are even not treaties, like Universal Declaration of Human Rights, they were showing kind of the willingness of the democratic countries and other countries who to take into account the importance of human rights provisions, but political considerations were very different. As I said, even the genocide convention was adopted and came into force because it was wanted. I mean, it united members of the coalition and anti-German coalition during the Second World War in punishing Germany primarily. So when there was a political will, and then countries would vote for. When there was no political will, or any of the countries, no matter which one, United States or USSR, had the feeling that this convention or this treaty, no matter how it's called, it might be covenant, it might be convention, were harmful for them, or were against their political environment in their own countries, or affected provide bad effect toward their own country, they wouldn't vote for. So I'm talking about it was very difficult to achieve political agreement, political will any of these international, that's why it was so difficult to unite, to get united around even the text of certain document devoted to human rights. Although everybody was saying, you know, we are all voting for human rights, we all want human rights freedoms to be not only how to say. Not only in the focus of the policy of of certain country, but of the whole international community, and the United Nations as the only international organization that was created after the Second World War. But at the end of the day, when they, if any of the provisions would affect badly the certain country or its regime, of course the representative in the international in the commission or in any organ of the United Nations wouldn't vote for, would vote against.
There wasn't a Cold War. I'm trying to be really difficult.
But the Cold War, there was a lot of ideological division too. That's the problem with the Cold War, but because we have ideological division. So, for example, for Soviet Union and for countries that were put into the Moscow umbrella after the Second World War, in legal literature and in legal theory, there was different focus on human rights. What takes priority? Were political or rights? That should we emphasize on political and civil rights, or we should emphasize on social, cultural, and economic rights? So that was a very big division, and that was different focus on how Western European jurists and scholars were looking at politicians, were looking to the human rights, not to mention the third world countries, not to mention African countries, because African countries and third world countries were also countries, especially after the decolonization, they were having a very big, weight into the General Assembly. And so many of the provisions came as I
Let me just interrupt and go back to what Elizabeth is asking. Say in a case like Burundi, I think it was in 1971, we do have mass slaughter taking place. Yet there was no attempt to, as far as I know, to apply the Genocide Convention there. Was there a discussion of it in the UN Security Council, or it just was?
Well, I'm not, I'm not sure whether if there was discussions, maybe it should be discussion, but the question is who would support that discussion.
Well, what about, say, with the Khmer Rouge? And I realize the Chinese supported the Khmer Rouge.
There were many.
And so was it because of Chinese pressure that there were no efforts to apply the Genocide Convention? Was it seen as not conforming to the definition in the Genocide Convention? Eventually, a long time ago, I guess it was about 14, 15 years ago, there was an international criminal tribunal, although it wasn't like the one dealing with the former Yugoslavia, because part of it was Cambodian, and then there were the international judges, I think it was, and lawyers who took part in the chambers that were set up dealing with Cambodia. And eventually there were some convicted, most of them were dead. Pol Pot was dead.
Yes, there was, but it wasn't, there was no, it wasn't called genocide, it was called crimes against humanity. That's the problem. That's the problem. Nobody wanted to go into this specific, yeah.
Yeah, actually, I want to just starting from the Soviet Union to clarify and ask some questions. And I guess both of the sides has a record of human rights abuses during the Cold War, both Soviet Union and United States, all of the sides. Starting from the Soviet Union, the quotations of the study actually it really fits the broad definition of genocide because it targets one particular nation. I mean, if we think in that way, Armenian issue in Turkey also would be labeled as genocide because of the dislocation of one particular nation, particular people. And the case of Ukraine and Crimea, actually during the collectivization period in Kazakhstan, also more than 1 million Kazakhs terminated
In the famine.
wiped out. So we always think Ukraine, but in other parts of the Soviet Union during the collectivization period of Stalin, there
Yeah,
were
That
kind of
was
this
in
kind of
1930s.
massive issues. And I am a little bit suspicious whether Soviet Union deliberately targeted Ukraine in 1932, because we saw that in Kazakhstan, Central Asia, it is a kind of failure of the collectivization of economic policies, in my opinion. And expand about the issue of United States. Actually, former Nicaraguan dictators, some of them, reported to say former US president, some of them is son, he might be son of a beach, but our son of a beach. Reportedly said by the US president. I mean, United States supported these son of beaches in Latin America.
Yes,
These
dictators,
Nadia
dictators, yeah,
dictators.
yeah, but that was,
In Latin America, Allende in Chile was overthrown by a US supported coup. In Turkey, in all parts of the world, in FMLN, in El Salvador, actually they made a social revolution, FMLN, but US, by US support.
But then Nadia mentioned all that. That's what she was getting at, the impact of the
all
Cold
these
War.
kind of.
Because they were anti-communist.
They
That's
were
why US
they got
leaders supported them. So
it
that,
wasn't
This
connected.
high level of-
but she mentioned all of
Isn't
this.
Democracy, isn't this democracy, this record? I mean, when you intervene the will of the people.
But that was the
That was
thrust of part of her talk, was that the Cold War had a pernicious impact on, on US policy toward human rights. When the Cold War ended, the United States withdrew its support
From those dictators.
from
They-
many of the, for almost all of those dictators.
Perspective, what about Hiroshima, Nagasaki, use of atomic bomb?
Yeah,
well,
wait a
that-
second.
yeah.
Let me make,
Yeah.
yeah, thank you very much for your questions. There were so many or comments and comments. I would like to specify and to point out again one important thing. So the Genocide Convention was adopted in 1948 and came into force in 1951. So all those, most of the events that you were referring on the famine in 1930s and Stalin's policy, and also you mentioned what was the other
The mass
event?
deportation.
The mass deportation also in Turkey. Also, all those events they took place before the convention. So the convention doesn't have, I mentioned this during my talk, that it doesn't have retrospective effect. So whatever happened, of course, a lot of crimes happened, crimes against humanity, I'd call them, because at that time, by 1948, we don't have international convention on genocide. So we cannot qualify those crimes as genocide. We can qualify as them maybe according to what we have until those days. We have crimes against humanity, but nothing else, not genocide. That is wrong. This is what is going on nowadays. That a lot of politicians and a lot of people, sometimes journalists, that are not well aware what exactly the Genocide Convention is and its provisions. They refer to those activities, those wars, those crimes before the invention before the convention was invented and before the convention went into force at all. So this is, I would say, this is not the right thing, and legally it's not correct to do that. So when we
But from
speak about the
let me just very quick, from a scholarly perspective, though, you can go back. I mean, for example, Lemkin did regard the famines in the Soviet Union, especially in Ukraine, as an act of genocide. And he also, in Norman Neymark, in his book from about 12 to 13 years ago, Stalin's Genocides, did regard the famine and the mass deportations, as well as the target, the war against the peasantry, all as acts of genocide.
Yeah.
So he applied it from an academic.
From moral point of view, from a scholarly point of view, but not from legal point of view. That's the legal theory and legal practice. That's the thing. So nowadays, many people also are making this mistake. For example, referring to Turkish genocide against Armenians as a genocide, but it's not genocide if you speak legally. If you speak as a human being, if you speak in moral terms, it is, of course, it is connected to the crimes of genocide, but it's not legally. So there was something else about United States and its support to dictators during the Cold War. It was also connected with the Cold War, the environment of the Cold War and the relations between the superpowers. Of course, United States decided when they decide to support some dictatorship, thinking, for example, or looking at them like that they can kind of, it was regarded as a part of ideological and political struggle during the Cold War, but then they would just leave them alone. United States, they would just leave them alone, those dictators, without any help when they are not needed anymore. Yes.
Go ahead.
I just wanted to know something. Was there any definition of genocide in the convention regarding numbers? For example, if you have many numbers exterminated, that's qualified genocide. If you haven't reached that numbers, it's not. Number one, and number two, are they also looking at some documents? Let's say the policy of a government, if they say somewhere in their documents that that nation or ethnicity has to be eliminated. Is there necessity to have a document in order to qualify it as a genocide, or it's just a matter of?
No, the convention is very, very explicitly says what is genocide and what you have to so it refers, as I said, it excludes political and social groups.
Yes.
This is very important. What that does mean that you cannot apply to the Soviet policy, to Soviet internal policy,
But there is no
and deportations of all these people. That
there are no numbers.
No numbers. A group. It says group. It says group. It says ethical, cultural.
It's in part for that
group.
reason that you get these efforts, about cultural genocide, which, for example, the Tibetans have claimed that the Chinese, even the Chinese have not slaughtered vast numbers of Tibetans, but they've certainly made it almost impossible for Tibetans to abide by, their cultural norms and the like. So it's been cited in that regard too. But yeah, as Nadia mentioned, the numbers are.
Yes, but it's striking when we have these regimes like Khmer Rouge and Pol Pot regime, and they are not qualified as a genocidal regime. It's just striking. There's so many documentary films, and in my classes I would show sometimes students the documentary films like to show what so the atrocities and it was enormous during those regimes, and they weren't qualified as genocide. It is
It's
just striking.
50 years ago
50
this month that the Khmer Rouge came to power in Cambodia and embarked on killing
2 million.
2 million people
2
out
million
of
people.
pre 1975 population of about a few under 7 million. So you're talking about close to a third of the population. But it was, as I say, they were the surviving leaders of the Khmer Rouge. There were some who were put on trial in 2010, I think it was. And,
Yeah, but again,
there were some convictions. but it was-
conviction wasn't for genocide.
It wasn't genocide?
No, it was crime against
crimes
humanity.
against
But
humanity.
2010 is already not the Cold War. No wonder why. No.
Yeah, like, until now, nobody wants, as I mentioned, so for example, for International Covenant for for political rights, we have additional protocols, 2 additional protocols. For International Covenant for Socioeconomic and Cultural rights, we have additional protocol, but not to the Convention for Genocide, and it's most needed, I think, and nobody wants to propose. And all these are political considerations. Lawyers know what is needed, and I think people also know, because we, as I said, unfortunately, we are witnessing every single day, even in the 21st century, the end of the first quarter of the 21st century, we are witnessing such crimes that are, it's hard to imagine.
Please.
Actually, he was before me.
Yeah.
Okay, so please.
No, please go ahead. Please go ahead.
Okay. Well, first of all, thanks very much. I have a couple of comments and then a quick question. First on Burundi in 1972, that was taken up in the United Nations, but effective action against the criminals founded on the fact that it was seen as primarily an internal conflict. Now, there was aid coming from the UN and other places, and Tanzania had a big stake in this because they ended up accepting hundreds of thousands of Burundian refugees. Just
So
very
was the
quickly,
discussion in the General Assembly or the Security Council?
now you're going to press me on details.
Okay, go ahead.
But it's easy enough to look up. Then very quickly, I really appreciated that the announcement for this talk had my favorite picture of my favorite First Lady, Eleanor Roosevelt, with the International Declaration of Human Rights.
Yes.
So thanks for that. But I wanted to ask a question that's everybody's touched on, and so more than one person could answer it, I think, which is that, and it lies in the basic aspects of the UN Charter. The UN has been pretty effective since it was founded, if not completely effective, in preventing international wars, especially world wars. It was much less effective at preventing crimes of various kinds, and not just genocide, but crimes against humanity and war crimes and things like that within countries because of the primacy of self-determination. So I guess the question would be, how can we correct or compensate for the mismatch between international law and national self-determination? Thanks very much.
So, and then Michael.
So how we can correct between international law norms?
Between international law and national self-determination. A lot of the crimes that can't be prosecuted are committed within national boundaries or by nations which can thumb their nose at international law and can't be held accountable. Even within national or international law.
I mean, I think part of it, Nadia, you've touched on this, not in today's presentation, but there was an effort in, I think it was 2006, to adopt a responsibility to protect doctrine at the within the United Nations. It was quite controversial for the reason you mentioned, that it basically gave a writ to powerful actors to intervene in other countries to either address atrocities that were underway or to prevent them from resuming. And so there has been an effort to try to deal with the trade-off you mentioned, but it's been very controversial.
Yeah, but that, this question, I think, relates to the question of the power of the international, the power of United Nations to what extent United Nations as the international organization has the right to intervene in the national within the national the state sovereignty. That is the problem, because international law deals with the relations between international actors. So what is going on in Britain? You said, for example, if we have human rights violation, of course, nowadays international organization, not only United Nations but other international organizations, can take action. But the question is, to what extent, what kind of action that they can take. So United Nations, we know, it doesn't have army, it doesn't have military power, and this is not the main purpose of the United Nations. United Nations also, the mechanism to take action against, for example, to intervene in internal conflict, this mechanism is extremely slow. It is very slow. So by the time the United Nations issues, for example, I just forgot some statement even. It takes so long that sometimes the conflict became a real war. So the mechanism is very extremely slow. There are a lot of steps that needs to be taken until the decision, takes a form of sanctions or some other statement issued by the United Nations. So what usually is United Nations, what they are doing, they are starting with sanctions. And what kind of sanctions can be? Economic sanctions or condemning violations. So in many resolutions of the United Nations, we initially see just condemning the bad behavior, in certain countries played by the government or by paramilitary forces or by any other forces. But otherwise, what can United Nations do? This is a sovereign country. So it's a question here between where sovereignty, to what extent the government gives away sovereignty. So this is a very interesting issue within the European Union. So because the government gives away part of its sovereignty to the European Union in order to gain something economically or culturally or militarily. But if a certain state is a member of the United Nations, the United Nations, what can do? It's a huge organization. By the time it takes action, in the country, the small conflict will become a war. That's why it is very difficult. So I like the notion that you actually said that United Nations was very effective in some areas, but it was less effective in many other areas. United Nations, there's a lot of debate, and this debate never ended about to what extent United Nations is effective organization, or to what extent it's not effective organization, and how there are a lot of proposals for the United Nations to be how to say reorganized, to be including the Security Council, because a lot of governments, new actors, powerful actors, want to become members of the Security Council. Why? In order to impose veto when they do not agree with the main proposal or the proposal of someone else. United Nations, I'm a big fan of the United Nations, and I think that United Nations
Let me, Nadia, we need to end.
We've got to do a follow-up seminar on this issue.
Thank you very
not
much.
as confident about, but let me thank you for